Buckle up. You are exiting the ordinary and entering the court gallery. Okay. How's everybody doing this evening? I have the hiccups. I don't know how this is going to go. Probably not smoothly. Ladies and gentlemen, I have an interesting show in store for you tonight. If I can make it through, letting you know what's coming up. We got one case with Judge Middleton. It's real interesting. He's got a lady in front of him who decided to bring her kids up to be thieves with her. I don't know. They were groomed to be shoplifters. Then we got a guy in Judge Stevens' court who decided he wanted to pay somebody for an alibi. And Judge Stevens gets to see all the evidence he needs to see of that. Expose that idiot in court. And then, when it comes to Judge Dad and people getting exposed in court for things that they shouldn't be doing, whether it be in court or not in court, yeah, it's Judge Dad. You just don't get away with stuff with Judge Dad. Not normally. I mean, sometimes Judge Dad can be a really nice guy. And we might see a little bit of that too. All of that and more on tonight's episode of the Court Gallery. And it all starts right now.
Good morning, everyone. We had a jury trial set for today. In fact, 7 or 8 of them. One matter has been dismissed, and I believe we've resolved the other case with a plea. And everybody is here, and we'll be addressing that here in just a moment. That may be our entire docket for today. Thank you for saying good morning. We have Deputy Michelle back with us today. I think they thought maybe we needed some help after the way things went yesterday, but I expect smooth sailing today. Mr. Truckee is here, Ms. Stoll is here, and we're going to start in just a minute. Today, you just get 2 lines, but this is easy. So easy, even Mr. Truckee probably knows it. When the sun beats down and burns the tar up on the roof, and your shoes get so hot, you wish your tired feet were fireproof. I can't give you the next line because that's the name of the song. When the sun beats down and burns the tar on the roof. If you sing it, good morning, Purple Pen. Thank you for saying good morning. That song's about 60 years old. Lots of covers of it. John Mellencamp does a good cover of it. So everybody can share that today. It's our little common humanity poetry. All right, Ms. Furlow, why don't you come up and have a seat? I didn't know if Mr. Mr. George was going to be in on this on behalf of the city.
We also have a city for this case. So,
Okay.
All right, these are a number of matters
Sir.
and, oops, thank you. Michelle's always there to tell me my recorder isn't on. All right, although Deputy Broker's pretty good at that too. We are on the record, we're on the live stream, and we're gonna deal with the matters of People versus Cinquez Marie Furlow. She has 1, 2, 3, 4, 5, 6, 7, 8 cases that were all set for jury trial today, and 1 case that has an open warrant that we're gonna deal with at some point this morning. Mr. Ross Truckee is here on behalf of the defendant. He and the defendant have been in contact, which has been helpful. Last week, earlier this week, Abigail Stoll is here from the prosecuting attorney's office. So let's go through these in chronological order. In May 23rd of 2024, in file number 24911 and 912, the defendant is charged with having no insurance on a motor vehicle and driving suspended second offense. Those are under state statute. In file 24964, it's alleged that in June of 2024, the defendant drove without a valid operator's license and with no proof of insurance. Those are under Three River City ordinance. I got my chronology out of order. April of 2024, excuse me, April 16th of 2024, the allegation is the defendant drove in the city of Three Rivers without valid insurance, left the scene of a property damage accident, had open intoxicants in a motor vehicle, had no valid license, had improper registration plate on the vehicle. That's actually, I think, the first one in time. December 2nd of 2024, she is charged in file 25358 with retail fraud, 3rd degree, in the Johnny Mart in Centerville, involved some items. Then we get into 2025 and file 25359 SM. The defendant is charged with 2 counts of domestic assault upon Skylar Ballard and assault and battery upon Craig Klaubenstein. And that was in Centerville Village on 2/6 allegedly and 25359. In June of 2025, the defendant was charged with retail fraud in the 2nd degree, alleging that she stole some liquor from Paul's Pantry in Three Rivers, and it was a second or subsequent retail fraud. 251406. (251764) alleges that in May, got them out of order, in May of 2025, that she did a retail fraud at Walmart of more than $200 but less than $1,000, and that was charged as retail fraud second. Then she also got charged with a retail fraud from July 31st of 2025, a retail fraud from the Shell Mart in Three Rivers. I believe that was also liquor. And candy. She had her children with her. There's an allegation, and that one is the one with the open warrant in it. Judge Pattison issued a warrant. I believe she failed to appear for something. So we'll deal with that as well. Ms. Stoll and Mr. Truckee, I know you're aware of all of these cases, including the ordinance ones, and you've been discussing them all week. In addition to that, Ms. Furlow has $990 worth of unpaid fines and costs for other offenses. And you've been working on a plea agreement to attempt to resolve everything. Ms. Stoll, what is the plea agreement here?
Your Honor, in exchange for a guilty plea to retail fraud second and one of the retail fraud files, the people will dismiss the remaining retail fraud charges. And then in exchange for a guilty plea to failure to report a collision in 24881. Oh, I'm sorry. A guilty plea to failure to report a collision and no valid ops in 24881. The people will dismiss the remaining charges in that file. And the people will dismiss the remaining charges in the remaining files.
So the domestic assault charge in A and B will be dismissed.
We couldn't, yes, Your Honor, we couldn't be contact victims.
What about the newest retail fraud from, that isn't set for trial today? Is that part of the deal
That's part of
also?
the package offer, yes.
All right.
Your Honor, we'd also be admitting to no valid ops in the city of Three Rivers case. Previously discussed that with Mr. George.
All right, and Ms. Stoll only has authority over the county cases. The Three Rivers ordinance case is 24964. Did you have a preference over which retail fraud you would rather
Yes.
plead to?
So there's 25358. That was a retail fraud third at the Centerville Shell. Well, we'd be willing to stipulate in there to a prior conviction and allow it to enter as retail fraud second at the course.
All right, let's go to that one. Give me the number again.
25358.
All right, 25358 is alleged to have occurred at the Johnny Mart in Centerville, and it's charged as a third degree. They did not allege that she had a previous retail fraud. So you'll allow that one. Wouldn't it be easier to just do one of the other ones, or this is the one that she has the memory of?
So I'm not aware that the charge in the July, Mr. Knopfinger's file with the
Yes.
open warrant, if that's a second, that one,
That is a second.
we would enter a plea in that case.
All right, that would be easier. To retail fraud second in 2520302 SM. All right, Ms. Furlow, let's take our time. We got all morning.
Okay.
You're going to enter a plea to retail fraud in the second degree in file 252302. That alleges that you were at the Shell Mart on South Main and you stole 2 bottles of Hennessy and some candy in July 31st of 2025. In 24881, you're going to plead to fail to report a collision and no valid operator's license. Operating without insurance, operating with an improper plate will be dismissed. Fail to stop, report a collision 257720 is, I think, 90 days and or $100. I don't think it carries any points. The charge of no insurance and driving suspended second will be dismissed. That's file 24911 and 912. You're going to plead to no valid ops in the Three Rivers ordinance case from June 1st. That was at Constantine and Broadway. That's 90 days and or $100. The retail fraud third degree from the Johnny Mart, which was also liquor, I think, is dismissed. The domestic violence charge, and this is a big deal. This is 25359. Domestic violence, 2 counts and an account of assault and battery. I don't know whether the victims agree with this or not, but that case is being dismissed, 25359. Those are all punishable by up to 93 days in jail. The retail fraud second degree at Walmart is also dismissed. That was in May of 25. It involved you and India Helper were in there and took some items. That's being dismissed. Items were worth more than $200. That's 251764. And then there is the Paul's Pantry case where you allegedly stole some high-end bottles of liquor, LeBron James Hennessy. That's filed 251406. That's retail fraud second. So 1, 2, 3, 4, 5 cases are being dismissed. No insurance, driving suspended second. Those are both punishable by up to a year in jail. A retail fraud third. Domestic violence on Skylar Ballard and Craig Klopfenstein. That's being dismissed 25359. A retail fraud at Walmart with a co-defendant is being dismissed. And then the Hennessy bottles from Paul's Pantry in June of 25 are dismissed. So that leaves 3 cases that we're going to deal with here this morning. So let's talk about those. Retail fraud second degree, the July 31st case from South Main Shell. That's a misdemeanor. It's punishable by up to a year in jail and a fine of up to $1,000. Potentially 3 times the value of the property taken, but I've never ever done that, but that's the maximum on that. On the accident from April of 24, they're going to dismiss no insurance. You're going to plead to fail to report collision. That's 257, I believe it's 620. That carries no points. It is punishable by up to 90 days in jail and a fine of up to $100. They're going to dismiss the no ops and the unlawful use of a registration plate and open intox. So it's a plea. In the no ops case from Three Rivers, no ops is a misdemeanor, but it's a minor one. It's punishable by up to 90 days in jail and a fine of up to $100. It does carry 2 points and it will go on your driving record. Do you understand?
Yes,
And are you going to plead to those 3 misdemeanor charges?
yes,
Other 5 cases will be dismissed.
yes.
All right. Did anybody promise you anything to get you to plead to this other than this plea agreement?
No,
Did anyone threaten you to try to get you to plead to these?
no,
All right. Do you understand that if you do plead to these charges, you'll be giving up your right to have a trial in front of a judge or jury? There will not be a trial. Do you understand that?
yes,
If you had a trial, you'd have the right to be represented by an attorney. Mr. Truckee is here with you. He's going to handle all these cases. You could also hire an attorney of your own choosing if you wished. If you had a trial, you would have the right to take the witness stand and testify on your own behalf. But you don't have to, because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you. And you have the right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. You understand?
yes,
All right, let's start with the easy one, the no ops. That alleges on this ticket that you were driving a car in Three Rivers on, print's pretty small, June 1st, I think, of 2024 at Broadway and Constantine. You got stopped for something and they gave you a ticket. Did you not have a valid license at that time?
no, I didn't have a license.
All right, I'll accept the plea to that one. Uh, 24881. This is quite a generous plea agreement. They're dismissing everything but failing to report a collision. On that day, April 16th, did you have a collision with another car on 4th Street in Three Rivers?
Yes,
And you were driving a tan Suburban?
yes,
And did you and this other car crash into each other and then you left?
yes.
All right, you had some buzz balls and chillers. This is Timothy Miller. Is this Deputy Tim Miller?
I don't think so.
Okay. All right, and then they found your car and had all your paperwork in it. All right. Failed to report a collision, as I said, is pretty straightforward. It doesn't carry any points. Everything else in there is dismissed. No insurance, open intox, no ops, unlawful plate. Then the last case we have, I think, is the last one in time. This is City of Three Rivers. On July 31st, last summer, did you go in the South Main Shell? This is all on video, about 9:30 in the morning. And you took 2 bottles of Hennessy and some candy
Yes,
and then left the store?
yes,
All right. Okay. That is a misdemeanor punishable by up to a year in jail and a fine of up to $1,000. This isn't a year in jail kind of case. All right, Ms. Stoll, what would you like me to do here?
Your Honor, we're still asking for restitution in all of the retail fraud files. There's a few different businesses that the restitution would go towards, but I have a total of $968 in restitution. Everything that the defendant's been charged with and that she's pleading guilty to is relatively petty and minor, so I won't recommend any upfront jail. I believe probation is appropriate, maybe 12 months or 24 months. I'm hopeful that the defendant takes this as an opportunity, sort of a clean slate, this fresh start to get her life back on track and be a good mom for her kids.
Mr. Truckee?
Thank you, Your Honor. I think we all get jaded sometimes in this job, and we see Ms. Furlow with her stack of files, and people start to think, what kind of a person is this? She's an indomitable person who has struggled and had a very unstable life for the majority of it. She's got kids at home. She had kids here one day, which Your Honor was not very thrilled about, but sometimes life comes into the courtroom. And you're well aware of the different medical issues that we've had that have kind of interrupted this case. But the thing that kind of really speaks to me about Ms. Furlow today is that you told her you'd put her in jail. And here she is. She didn't run. I think there was a long time in her life where she'd have just not come again and not come again.
Well, these files are full of failure to appears and bench warrants and but we are here today and we resolved 9 or 10 cases. So that's good for all concerned.
I would also note that during the colloquy here, there was an excuse making and stops put up. It's yes, yes, yes. This is a step toward atonement and a step toward contrition to say, I really did go on a tear from April of 24 to July of 25. And if you ask Ms. Furlow, she'll say that there's something with her, whether it's a midlife crisis or a nervous breakdown, but she was striking out, lashing out at society in a way that you call for help is kind of a cliche, right? I'm not going to use that, but there's obviously something going on with her when this happens again and again. And I don't think it's just, I want some liquor, I'm going to get some. I think there's a little bit deeper seated issue to it. And I think Your Honor's been aware of the family for years and knows that there's been kind of a similar trajectory that's been altered for some siblings of hers and for her mother too. So this is something where Miss Furlow, she's in her 30s now. What she shared with me is that she looked around and said, I'm in my 30s now. I got a pile of kids. What am I doing here? I'm not 17. These are teenager crimes, a lot of them. And she wants to change. She'd like your help changing. And that's why we'd ask that you offer a probation that would allow her to have some guardrails put up, continue with some therapy, get into some therapy, and work on herself. You know, she reports to me that talking to God works, but she wants somebody she can talk across the table to also. So these are the things I hope we can do and that she can make a big change. I don't know if she has a statement for you or not. We ask you to follow the prosecutor's recommendation. Thank you.
Ms. Furlow, what would you like me to know?
I'm trying to talk about. Hold on. Sorry.
You're all right.
Okay. I think I can't say I was going through. I don't know. Honestly, I was going through a midlife crisis. I don't know what I was going through, and I'm not about to sit here and make an excuse out of it. But okay, trying not to cry. And I am guilty of all that I just plead to today, but I do have kids, and that's my main concern. And I've been moving on like I don't want to do this stuff no more. I'm tired of coming to this courthouse.
I don't doubt that.
My kids are getting older and they see that. And usually I am not gonna lie, I did not care. I used to didn't care.
That's my sense. All of this is, I don't care.
I used to did not care.
All right. It's like, I don't care. I'm going to drive. They know
I
I'm
used to
suspended.
just didn't, I don't know what it was, but my kids, yeah, it affected me. I don't want to keep coming into this courtroom or looking behind my back or not being able to go take my kids somewhere because I got a warrant or I'm running.
Well, that's the good news. I'm going to recall that warrant. You pled to that. And there won't be any open warrants, as far as I can tell, for any of this stuff.
Just don't want to go through this stuff no more.
All right. I don't blame you there. And I don't have a bad relationship with your family. I've known them for years. They came to my mom's funeral. And I've known you since you were a kid.
Yeah. But
you got a lot of bad decisions.
I know.
Well, let's take the easier ones one by one. 24881 that failed to report collision is you did, each of these files is full of you failing to appear. This is a bad case. You crashed into somebody, you left, the car was full of alcohol, you just took off, but you did 1 day jail and then another day jail when you failed to appear. I'm going to 2 days jail credit, 2 days, giving no additional jail. The minimum fine was $125 or 2 days in jail. Everything's going to be concurrent. All right, that takes care of that incident from April 16th. All right, the no operator's license from 3 years. Your license is in fact suspended, has been for a long, long time. You've got no ops going back to 2011. See how much jail time you, again, all these are full of failing to show up. I think I might have $200 of bond in that case. Let me look. 964. No, that was with a surety. So there's no money in there. But again, multiple fails to appear. Let's see how much You didn't show up for your arraignment. You didn't care. 3 no-shows. You got arrested in May of 25. I think you did 1 day, then you post a surety bond. 1 day. Credit 1 day. Leaving 0 days to serve. Minimum allowable fine of $125 or 2 days. Concurrent with the other cases. 252302 SM. The 2488. All right, so the collision one is done, the no ops one. Collision one was bad. No ops, not so much. That leaves us with the retail fraud from South Main Shell on July 31st. In that case, according to the affidavit, and all these are on video, which is why I said you don't care. The Paul's Pantry is on video, the Walmart is on video, the Centerville one is on video. You took 2 large bottles of alcohol and she held her purse open while her young daughter concealed the items in the purse. The stolen merchandise was $110.03. Left the store without merchandise. I reviewed the footage, shows Sinquez selecting 2 bottles of Hennessy and concealing them in her purse. She selects small snack bags of candy and sweets and conceals them in front of her children as well. She then holds open her purse near the ground while her daughter, believed to be Jade McClinton, conceals a small item in the purse. And that is alleged to be a second or subsequent offense. The Paul's Pantry case, you were by yourself. No, you had your daughter with you. You went into the store and stole 2 $80 bottles of Hennessy, $40 bottles of Hennessy, and a young child was with you. And there's video of that. That's $80. That one's dismissed. The retail fraud from Walmart, I can't tell what it was. It says it was items. I don't know what that was. The domestic assault charge is dismissed altogether, so we don't even need to discuss that one. The retail fraud from Johnny Mart in Centerville. Again, you had your child with you. And that was $33 worth of food. And then the no insurance and the driving suspended charge from Constantine is dismissed. You have several previous retail frauds over the years, going back quite some time. You have unpaid fines and the truancy, which I can wipe out. It seems to me we tried a probation before without very much success. You were on a crime spree and you just didn't care. You got multiple prior criminal offenses. In each of these retail frauds, you had your children with you. And this one that you pled to, your child helped you with the theft. The files are full of failing to appear with bench warrants. And as I said, you've got $990 worth of unpaid fines. And so it's not a very pleasant picture. This one, I'm going to recall the warrant because she pled on this one. 2302 recall warrant. Let's see if that has any jail credit in it. PR bond. You got arrested on the 22nd. You bonded on the 22nd. You got 1 day credit. You can't just do this over and over and over again without a consequence. And you've been ducking the consequence by failing to come to court. And I respect the fact, as Mr. Truckee said, you're here today to face the music and everything is resolved. So going forward, you won't have a warrant over your head. You won't have me supervising. I'm going to do 0 fine. You already owe a bunch of money and you don't have much money. And 75 and 50 is 125. 2 additional days. I'm even going to waive your attorney fee. Although Mr. Truckee certainly earned it in this case. This is concurrent with the other 2 cases. 24964OT and 24881SM. I'm ordering 91 days in jail, credit 1. You're going to jail right now. I'm also going to wipe out the money that you owe me in the truancy case that's never been paid. The cops have been chasing you for 1.5 years and we finally resolved everything. But you've earned every day of 91 days. So you can go with a court officer. I will wipe out the fine that you owe in the old truancy case. You'll get good time credit, 90 days minus good time is 75 days. If you're a trustee, you'll be out sooner than that. I'm not doing a probation. I am ordering $964 worth of restitution.
Your Honor, we'd ask that any restitution sourced from the case of the co-defendant be reserved or made joint and several. You indicated a co-defendant on the Walmart.
Yes, and that's fair enough. All right, Ms. Furlow, best of luck. I hope I don't see you for the rest of the year. All right, I will additionally wipe out the fine owed in the truancy case. Which is 191326 SM. Failed to pay fine and cost. I can't wipe out the civil infractions, but I can wipe out any unpaid misdemeanors. And that'll be one less thing she has to deal with. We'll order 2 days. Truancy carries a 2-day jail sentence. Concurrent with the retail fraud 252302 SM. Well, we didn't have to try 9 separate cases. We were able to resolve everything. I think she made provisions for her kids. Her mom ends up helping her a lot, carrying her freight, but Cinquez knows what this is about. All right, I thank you both for the hard work you did to resolve all these cases. Some of these would have been pretty easy to prove, just show the video. One thing that offended me is she had her kids with her on each one of those thefts, and they even participated in some of it. All right, let's hope she can get out. I think Mr. Truckee, maybe she did current corner. She seemed to have a good attitude today. She was here ready to face the music and she knew I was going to put her in jail. All right, well, that finishes our Wednesday. You guys can each take the rest of the day off, go out to breakfast, go out to lunch, go for coffee. All right, that finishes our record for today. Good morning, Sergeant Rice.
In 25 CR 335, sir, you or Darren Porter with Mr. Just a second. Yeah, he needs to, while I'm taking that, he needs to, I need to talk to him personally because we had some chats and commitments and they're not being followed. On Mr. Macon on Mr. Porter. No, okay, we're in, this is a difficult one here. You're talking about habitual felon on this one? He's charged with a second degree felony of burglary of a habitation. In paragraph 1, he's been convicted, it states in 89 in the old days, burglary of a building, which was a felony back then. And then thereafter, it alleges that after that was final, he committed the felony of sexual assault of a child, a second degree felony, and was also convicted next door in 2005. And then now this happens. So if all of this is true, you're looking at a minimum of 25 years in prison, minimum to life imprisonment. You understand? Yeah, that's easy to understand. I mean, it's numbers, and you get punished not only for the crime but for criminal history. So criminal history can enhance the punishment range, and it does in this case. And that's why I always tell people, don't commit crimes. And I'd be out of a job, and I think I'd like it. It'd be a better world. That's what I want, a good world. I see in the file, the state has filed a motion to increase bond.
That's correct, Judge.
It was filed January 22nd.
That's what today is set for, you.
What is his bond?
You don't have that over 30,000.
Okay. Let's see where we are here.
We're prepared to go forward with a hearing, Your Honor, on these allegations.
What does that mean? I mean, a trial?
He's not, well, it's going to be a trial on the case in chief, but Mr. Ham has made some allegations that he's threatening or trying to interfere with a witness. And we're prepared to go forward on this.
All right. Go ahead. What do you want to present?
Yeah, my witness is outside the courtroom. I'd like to call her if you want to. I'm just checking to see if you want to do it from the table or from here or from the tables.
This is fine.
So call Mary Griffin.
This bond, I don't believe was set by me. I think it was set by Justice of the Peace in this.
Yes, sir.
And what's right off the bat on the four corners is the grand jury indicted you for burglary of a habitation, but you have a burglary of a building conviction in 1989. Burglaries are burglaries are burglaries. That concerns me.
He received a 5-year sentence for that, Judge.
I wonder why that didn't make an impact. I'm speaking rhetorically. Why that wouldn't have made an impact. It's like touching a stove. You get burnt, you got 5 years imprisonment, right? For the burglary. Didn't you?
Actually, yes, sir.
Okay. Here you are for another burglary. Now we're presumed innocent, but that can affect the bond because it's a similar type crime.
Griffin?
Raise your right hand, ma'am. Do you solemnly swear or affirm the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Lower your hand. Thank you. Go ahead. State.
Can you state your name for the record?
Mary Griffin?
And do you know a man by the name of Darren Dwayne Porter?
Yes, sir.
Do you see him here in the courtroom today? Can you point to him and identify something that he's wearing?
Well, for sure.
And may the record reflect she's identified the defendant,
Yes, it
Darren.
will.
And how do you know Mr. Porter?
I was engaged to him. We lived together for 6 years.
So time is going to be relevant here.
I was going to ask you, I bet I stepped on what you got. When were you married to him? What period?
Not married, engaged.
Okay. What period of time was that?
From 2019 to February of 2025.
Okay, thank you.
All right, so, and that's where I was headed. The engagement ended a month after this particular charge. Are you familiar with the charge that he received of an offensive burglary habitation that was supposed to have occurred on January 5th, 2025?
Yes, sir.
And has Mr. Porter had conversations with you about that date?
Yes, sir.
What were the nature of those conversations?
Mr. Porter informed me of his arrest, and I had already moved out at this time. And he asked me if I would be willing to write a letter for him stating what he wanted me to say, and he offered to pay me $100 to do it.
All right, so put it in common nomenclature. He was asking you to be his alibi witness?
Yeah,
Were you all
for a fee, yes, sir.
for a fee? And we actually talked about the amount of money that he offered you. Can you tell the judge what that was?
$100.
So not really much in the big picture of things, but he was seeking your testimony, asking you to basically be a paid witness for him as an alibi.
Yes, sir.
How did you react to that?
Well, then I wasn't gonna perjure myself for him.
And at that time was,
Did he ask you to perjure yourself?
Yeah,
Okay, maybe I'm stepping on you. Go ahead.
all right, so specifically, he was asking you to say what, ma'am?
he was asking me to specifically state things that were in the back of his truck, according to what he said were in the back of his truck when he left the house that morning, that were not there.
All right, so he was asking you to remember back to January 5th and state certain things about it.
Yes,
And the things he asked you were untrue.
yes,
And that's where your problem was, right?
yes,
At that time, was he represented by a different lawyer?
yes, sir.
Did you advise them that there was a problem in that regard?
Yes,
Who was that?
That was
Right.
Brian Lane, wasn't it?
yes,
And you actually know his assistant
Lynette, yes,
and you talked with her about that, right?
yes, I did face to face and over the phone.
Specifically, did she advise you to just be truthful about whatever testimony there is?
She advised me to do not say anything that was gonna get me into trouble.
All right, so did you write the letter he asked you to?
I did not, he did not, I wrote a letter from what I know.
Yes, ma'am.
When he got it, he crumbled it up, cussed me, shot me the finger, and told me it was not what he needed for me to say. So, then I'm not gonna say anything, I'm not gonna lie.
So whenever you found out that we had this case here, did you actually contact me in regards to some of the things that were taking place?
Yes,
Did you volunteer to come in and give a statement?
yes,
And did you do that, in fact, via video?
yes,
Other
Have you
than,
had a chance to see that
No.
statement? Okay.
it's a part of the discovery, Judge.
Okay, I just was gonna make sure Mr. Macon has an opportunity to see that. When he was delicious, thank you.
And in addition to that, did you provide text messages that you received from him about his attempts? I call it influencing your testimony, but obviously we're covering a lot of things here.
yes, sir,
And have you told him you didn't want to be involved?
yes,
Does he continue to try to contact you in that regard?
yes.
Hold on, help me out on dates or times.
So I'm going to get
that I
specifics if I
understand.
could, Judge.
Go ahead.
In fact, I advised you at some point in time that I let his lawyer know what was going on and I had filed this motion to increase. Do you remember that? I told you for your safety, I'd let the lawyer know, kind of be aware that he may be contacting you.
Yes, sir,
What date was that?
January 26th,
How much did he
Of this year?
yeah,
Okay,
How much has he tried to contact you since that date?
that was the date he
Yes,
tried
ma'am.
to contact me.
Yes, ma'am.
I don't know, I showed you the text messages, 8 or 9, and a missed phone call that same day, because I didn't answer.
So all on the same day that we let the lawyer know and we filed the motion, he contacted you with 8 to 9 different texts and attempted to call you.
Yes,
Are you aware that I advised his lawyer that the contact needed to stop?
no, sir, I was not aware.
I didn't tell you that in our phone conversation?
No, you didn't tell me that.
May I approach, Judge?
Yes.
I'm gonna show you collectively what on the mark is, State's Exhibit 1. Ask you to look at that. Are these the text messages that you provided to our office?
Yes, sir.
Go ahead and look through them.
Yeah, that's all of the ones I sent you.
All right, so since some of these appear in a different format.
Yeah.
We'll mark this as State's Exhibit 1. These are the ones with the darker colored format.
That's the Facebook Messenger messages.
Thank you. That's what I was going to ask you. How did you receive these? By what method?
Facebook Messenger.
All right. So if we look at State's Exhibit 2, that's one with a lighter background. What texting message was this?
Regular phone texting.
All right, so this would have been on your cell phone. This was, which is States 2. States 1 is via a social media texting. How can you be certain that it's Darren Porter that sent you these things?
Well, that's his name and number, so,
Had he contacted you via these means prior to
yeah,
this case?
for 6 years, yes.
So when we look at State's Exhibit 1, does it identify an individual by the name of Dwayne Porter as sending those messages?
Yes, that's his middle name is Dwayne.
And is that how you know him via the picture on Facebook and Facebook Messenger?
Yes, that's our dog.
Are the dates and actually on these, I see a time of 6:02. Do you know what date that was received?
Oh, that's from my phone, the time that I sent it to Mr. Turner.
Okay,
I mean, I could go back and look at the dates that were on it. Most of that.
last page
That's
indicates,
August 4th. Yeah, most of these were during the summertime. That's right before his first court date he had. He was trying to get me to do the letter.
so can we assume that these are August 4th of 2025?
August 4th and before.
Okay,
Mhm.
let's switch over to State's Exhibit 2. This is identified as DP, Darren.
There.
Is that how you identified him in your cell phone?
Yes, sir.
These are notated with the dates that appear to be August 4th and some times. Is that of 2025?
Yes, sir. Yeah, he went back and forth between the two. Was messaging me, alternating.
There you tell your State's Exhibits 1 or 2.
We have no objection to them.
They are admitted.
All right, so let's start with States 1, the Facebook Messenger. What's the gist of what the judge is supposed to be getting here out of this conversation there?
Basically, it's him asking me, am I going to help him? Let's get down to business.
What is the help in the business?
Him wanting me to write him that letter. And then he's telling me in there that he's gonna compensate me for it.
All right, so that's the gist of State's Exhibit 1. State's Exhibit 2, around August 4th, where at some point in time, did you have him blocked and then unblocked him?
No, he had blocked me and then he unblocked me. And then he was asking me, was I at lunch yet? I told him not yet, but I was gonna be there shortly. And he said, okay. And then he kept on about asking me about, was I gonna help him? Are you gonna help me? Just tell me if you're gonna help me. I told you I would compensate you, all of that.
In fact, in this message, there's a reference about the offer I made him before, is there not? Is that a yes?
Yes, there is. That's all.
It's clearly talking about the situation, what he's dealing with, right?
Yes, sir. It's clearly talking about it, talking about how, it was 25 to life and then 15 years and, yeah. Clearly talking about it.
This paragraph here, which begins with basically, is he talking about the facts of the case and the allegations here?
Yes, he is. And that's what he wanted me to put in the letter too.
All right, so he wanted you to say, basically, Because basically, again, it's nothing but point of a finger. Like I said in the first report, nothing is said about a house. The second report, all of a sudden, there's a window raised and I pulled the cord out that's two conflicting stories on two separate days. You just can't keep adding, especially on the first report. You have 5 more lines you could have used. I'm going to take a picture of both of them. And I think it gets cut off there and show you tonight.
Yes.
What's he referencing there?
He is referencing the victim's testimony,
That's right.
his written statement to the police. He said that it changed multiple times. There was one version in the beginning, and then it changed to an extension cord being taken out of a window. And that's what he was saying, that there was 5 additional lines originally on the first statement, that the man could have put that, and he didn't, that he changed his story and added more stuff. And so that's what he was telling me about.
All right. So
I'm a little fuzzy here. Are you talking about the complainant? Is she referring to the?
yes,
Yeah,
The complainant
in the burger of a habitation.
yes.
And I'm a little fuzzy about this. What is the connection of the defendant to this building, this home? And
That's unknown, Judge. I don't.
There's no connection.
what's the connection of the defendant to the complainant? Here.
None.
Oh,
He didn't know the complainant and he does not know the house.
this just chosen at random?
Yes, sir.
There are other facts involved.
Okay.
All right.
I
So
didn't know if that was her home before
No.
or they were living in or something. That was fuzzy.
so these messages, and specifically that last little bit we were talking about, is him trying to get you to write that letter,
Yeah,
and which you've not done.
no,
And now that we brought it to the court's attention, what text did he send you on January 26th? Like, pull out your phone and read them.
Are you asking for State's Exhibit 2 to be placed in that?
I asked for both states 1 and 2, and I believe there was no objections, Judge.
And they're admitted. If I did it already.
first he tried to contact me via phone at around 2:35, January 26th PM, and I did not answer. He sent me a message on Facebook Messenger at 2:36 PM and just said my name, Mary. At 3:12, I messaged back and said, do not contact me again, as I was instructed by the DA's office. He messaged me again and said, what do I do with your mail? Now, I haven't lived with him in over a year, and he's just now asking me where to send my mail.
Didn't he specifically ask for your address?
No, he didn't.
Okay,
He just asked what to do with my mail.
okay.
And I simply replied 3 letters, RTS, return to sender. That's all I said.
And that's the only reply you gave on January 26th of
Yes, sir.
2026.
Correct.
Have you repeatedly asked him to stop contacting you?
This was the last time I asked him to do not contact me. I have not replied to any of the other messages that came after that.
Have I covered the extent of what he's talked with you about, ma'am?
Yeah,
I've passed the witness.
Go ahead, Mr. Mason.
Ms. Griffin, you had a 6-year relationship with Mr. Porter,
yes,
and it ended, and he subsequently got married to another woman, correct?
no, that's not how it ended.
Did he get married to another woman?
I don't have any idea what his personal life is.
Okay. Didn't you and Mr. Porter have a bunch of controversy over $10,000 that was missing?
No,
Didn't he loan you $9,000 for your son?
no,
Yep, okay. But she's denying that, but
Yeah.
I'm curious what that has to do with the subject matter that we how's that related to this hearing? Anyway, I'm lost on that one, but she's denying it. So, and the questions of attorneys do not constitute any evidence.
I'll pass the witness, Your Honor.
No further questions. This witness asked it should be excused.
Let me, before that
Yes, sir.
happens, what is the relationship to this witness in the state's case here in this indictment? If any?
She wasn't going to be a witness until she reached out to me and told me that he was trying to purchase her alibi testimony. So I'll be bringing her in the state's case in chief if this case goes to trial.
And you're talking about this burglary of a habitation indictment
Correct.
in this cause number we're here for.
Anytime a defendant tries to solicit testimony via paid or otherwise, I will bring them in to come testify.
Mm-hmm. It is a crime if a person commits the offense of tampering with a witness, which is with intent to influence a witness. He offers, confers, or agrees to confer any benefit on a witness or prospective witness in an official proceeding, such as an indicted case in my court, or he coerces a witness or prospective witness in an official proceeding. And one, to testify falsely is the first thing out of the box. Or two, to withhold any testimony, information, documents, or things. And there are three other methods of committing such a crime. But I think what your testimony that you're standing behind is section 36.05, subpart A, subpart 1, to testify falsely.
Yes, sir.
And that is a felony of the third degree, which carries with it up to 10 years in prison. If you have prior convictions such as these listed in this indictment, then you're looking at another habitual felony.
Yeah.
All right.
May she step down, Judge?
Yes. Do you need anything more from this lady? You may, I'll be seated. What's the state intending to do with that subject matter?
We don't typically like to intake matters at our office. I'll probably refer it to a separate law enforcement agency to finish the investigation and look at determining the filing of this additional criminal charge.
Right. Anything else you want to add on this?
Not as far as evidence goes, Judge.
What do you want to,
Yes, Your Honor, I call Mr. Porter.
the defendant? Dennis, would you please tell the jury that we're going to need for them to relax, and it's going to be about 30 more minutes because of some matters that have arisen. Thank you. Raise your right hand. Do you solemnly swear or affirm any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God? And do lower your hand. Please. Go ahead.
Did you have a relationship with Mary Griffin?
Yes, sir, from 2018 to 2024.
Okay,
No, 2025.
okay. And did you talk to her about writing a letter, what was in the back of your truck?
So what has been,
That's yes or no.
yes,
Then he can ask this next one.
Did you ask her to lie or tell an untruth at any time?
no, sir.
There's been talk about your offer to compensate her. Was that for the letter or for something else?
That was, for the letter, but the compensation was that I would still be there for her whenever she needed me, because she had just, called me and I helped her in the last 3 weeks prior because her son, I had no contact with her since March. And so she called me and, distraught because her son had a heart attack. And if I'd be there for her, and I said, sure. And so compassionately I did. And, I gave her money for snacks up there at the hospital, so on and so forth, brought her food. And then afterwards, she said, well, what can I do for you? And I said, well, I need some help. I need you to help me out and be a witness, because you know what was in the back of my truck. And I said, I told her, and not so many words through the text messages that I would compensate her, which meant I would still be her person, which is in that text messages. Had nothing to do with monetary value.
Did you subsequently, after breaking up with Miss Griffin, get married?
Yes, I did. And I told her I was getting married in November. She tried to call me back to get back with her on the November 24th. I told her there was no way, too much water under the bridge, too much control, too much trying to just keep me wore down, control. And enough was enough. And I went on to better my life.
So it's her,
And-
so with it, it's her fault.
Sir,
It's her fault.
I was I was so controlled that when I was getting my Class A CDL in February, 2 weeks before I went to take my test, she begged me not to take the test, and that she would give me $400 out of each one of her paychecks if I would just take the job that I got, because that way she could continue with the trackers on my truck, and there's no trackers on an 18-wheeler at my job. So therefore, she didn't want me to go anywhere. And I said I couldn't do it anymore, that I want to work. I've been a Boilermaker all my life, and I wanted to work, and I wanted to advance in this company. And I got my Class A CDL. And the day I got my Class A CDL, she left before I even got home from Longview from taking my test.
Go ahead.
And then there was nothing from March until June. He had a heart attack. She called me out of the blue. I'd be there for her. I said yes. And that was it. And I did not ask for any compensation as far as monetary value to get the letter. She said that she would gladly. And she wrote the letter. I have the letter. I gave it to Mr. Macon. I did not crumple it up, and I did not shoot the finger at her, what she said. It's intact. And there's no pieces from being crumpled up. Since then, she has called and tried to sabotage our relationship. My wife has the text messages, and I've asked her to leave us alone. She knows we got married, and this is why she's doing what she's doing.
So
Hold on. I'm just. I'm a little confused here. This state's exhibit 1 that's been introduced. These are your statements, right?
Yes, sir. I don't deny any of
Okay.
it. It's just that I did.
Mary, please, are you going to help me or not? Everything else is frivolous. Sounds like whether she helps you or not is of primary importance to you. What you do is none of my business. That's why I don't ask, and vice versa. I told you I would compensate you helping me. You don't have to. That's why I'm going to compensate. That's the only thing we're dealing with right now.
Yes, there was
That's
phone
pretty
calls.
insistent.
There was phone calls in between the text messages, and we was talking, and then I would, and then she would get mad and hang up. But in those phone calls,
Well, hold on. I'm just fuzzy. What is it that you need her help with? Since everything else in the world, in your life, and the existence on this planet is frivolous, other than that primary need of yours. What is this primary need?
so that phone call consisted of.
What is your primary need that you're expressing in words here? You're going, please, are you going to help me or not? Everything else is frivolous. This is the most important thing right
Yes.
now in existence in the universe. What is this most important thing?
She asked how she could help, and
No, what is this important thing
Help.
that of what, sir? You're dancing around this issue. Helping you what?
helping me with this case, because
This
she
case.
knows I was innocent. She knows I was innocent.
I would compensate your helping me.
Yes, by being her person, and I have that in the text message. Which means I will, anytime that anything goes wrong in her life and she needs me, I will be there. She always called me her person. Even the day she called and her son had a heart attack, I said, why you calling me? She said, because you're my person.
I know you're making this sound so selfless on your part, but you say, are you going to help me or not? Everything else is frivolous.
Yes,
It's your need.
talking about relationship.
We can talk over each other and that would be inappropriate. You're going to keep speaking over me? Let me speak, then you can speak. Number one, it's rude not to, but number two, she has to take all of this down and she can't take when two people are taking down.
Yes.
And you seem to be a very aggressive, controlling kind of person, but relax. Okay, you'll get your chance to be heard. Are you going to help me or not? Everything else is frivolous. That's pretty succinct. This is whatever this is that your needs are. If this is your need, it's more important than anything else in the universe, according to you. What you do is none of my business. That's why I don't ask, and vice versa. I told you I would compensate you helping. That's the only thing we're dealing with. You're talking about compensating her to help you in this case.
Yes, sir.
You see anything wrong with that? Because when somebody is a witness that may help you, you have a right to get that. And they're subpoenaed and they come under oath, and based upon the sanctions that perjury can bring about, people better tell the truth. They don't get paid for being a witness generally. But what is it you're paying her to say?
I never offered to pay her. I always said.
Wait. That's what I would compensate. You're helping me. Didn't you say that? There it is.
And I didn't mean it monetarily. She
Well,
talked about,
wait. What compensation are you talking about?
in return, my compensation would be to help her anytime she needed me.
Oh.
As I did with her son.
Just being a wonderful guy.
And that was, yes, and I was.
Okay. Well, no, sir. You've been convicted of felonies twice. That's a character issue, haven't you? I'm sorry. That's what the grand jury says, that you were convicted of burglary of a building, which is similar to what you're charged with here, burglary of a habitation.
Well,
And then, hold on, and then sexual assault of a child. You were convicted of that, weren't you?
and
Do you find that, is that true?
yes, sir.
Isn't that serious?
It's very serious.
Okay, all right.
But by the second, can I say something? now?
Yes.
By the same token, on each one of those cases, it was a finger point, and my lawyer's done nothing. Rife Kimler, I sat right there in Walker's court, and Rife Kimler denied me and my 5 witnesses to testify, then straight up denied me.
So it's somebody else's fault.
Well, I was begging.
No,
to
is that
testify.
yes or no? It's somebody else's fault.
It was Rife's fault.
Okay.
Or it was my fault because I didn't get a better lawyer. I didn't know how to get a
Okay,
lawyer.
but it was somebody who didn't do their job. But you have been convicted twice on two separate serious offenses, and you're saying that wasn't your fault.
No, sir, it wasn't.
Is that right?
I didn't get my day in court.
Sir, were you found guilty? You have a right to appeal. Did you appeal those cases?
Yes, sir.
And what were the results of the appeals? They were affirmed, weren't they?
No, sir. Brian Lane's still working on my case.
No, sir. Have they been overturned?
I'm working on it.
Sure. Until they are overturned,
Yes, sir.
a conviction is valid
Yes, sir.
unless it's overturned.
Yes, sir.
I'd like to see the future that you're looking into, but and we're talking about a conviction. First of all, in 1989, that's 30 some odd years ago, 37 years ago. And, that appeal is way out of time. So the only thing you would have would be a writ of habeas corpus. Is that what's being done?
I didn't try it. No, sir. It was a,
So you're not appealing that case?
no, sir.
That's what I thought you inferred to us a little while ago.
No, sir.
All right.
The
Then
second,
the next one is 2005. That was over 20 years ago.
yes.
You don't have much of an appeal at this time. You may have a writ, but an appeal is way overdue.
No, I started the appeal in 2018, 2 years after I got out. And
That
I
was-
got the money to get it.
Okay, isn't that 8 years ago?
Yes, sir.
Okay, what's the result of it?
I don't know what's happening. Yeah, I
Oh,
was down Brian Lane.
well, look, then, look, a conviction is valid unless it's overturned. Unless that happens, you can sit there all day long and cry foul, but it's the way it is. But you have 2 convictions,
Yes, sir.
and they make up part of this case and its punishment, which subjects you to 25 to life. Anyway, we can beat this one a while, but State's Exhibit 1, which is part of the record, clearly states, and you've made it clear that you're referring to this case and you're willing to compensate her for help in this case. And that seems pretty clear.
Sure.
What else do you want to ask?
Questions from?
The only thing I want to ask you in regards to just this issue, I've got plenty other things I'd like to talk about. But I want to know if you're going to admit that you texted her January 26th of 2026.
A week ago?
Yeah, just a week ago, after you found out about this motion, did you in fact engage in text that lady right out, just like she testified?
I had no idea.
Yes or no?
Yes, but I had no idea she made the complaint. I had no idea. I didn't know who this was. You can ask my lawyer. I had no idea.
You're going to tell me that this
Well,
lawyer,
let him finish, please. Go ahead.
I had no idea. Yes, I've come to him and we thought this whole time it was another woman named Denise that stole $10,000 from her, my wife. I had no idea that it was this person at all.
so it's just ironic that the same day that you talked to him is when you reached out to her.
I reached out to her because I got a letter in the mail that was opened already and on the ground, and it said municipal court in Nederland. And I simply asked if she had a ticket that I'd help her with it.
I don't have any other questions.
With all your troubles, with all these fires, these raging fires that are occurring right now, you were worrying about her traffic, some municipal ticket. That's what you were spending your time on? Is that right? When you have all of this looking at 25 to life? You're saying you stopped what you were doing and were curious about whether she had a municipal city ordinance ticket?
That's what she failed to, it's on the text message that she failed to
Okay.
provide that. Yes.
Anything else?
Mr. Porter, are you employed? Are you employed?
Yes, sir.
And whatever conditions the judge imposes on a bond, you'll follow those, right?
Yes, sir.
And you'll show up in court when you're supposed to,
Yes, sir.
if nothing further on.
All right. Go ahead. Anything else to add?
No, Judge, you've
Got to
covered
catch up.
a lot of what I wanted to do. So in the nature of time, I'm going to pass.
Summarize. What what relief are you asking? And then Mr. Macon, what you respond to. Go ahead.
Judge, based upon the testimony from both witnesses today, I'm not convinced that there's a bond amount or conditions that can guarantee the safety of one, the witness that just testified, and two, the community in general. In that regard, based upon the motion to increase, I ask that Your Honor revoke the bond, which in my opinion was insufficient, and let's leave him waiting trial.
Go
But
ahead.
as for no bond.
Go ahead, Mr. Macon.
You know, we would naturally disagree. We think any bond Mr. Porter made, he would do. He would not contact anyone. He doesn't represent a danger to the community. He's employed.
All right. What is his bond right now?
30,000, you know.
Okay. The court is going to keep you on a bond. Your bond, though, is doubled to $60,000. And you must have a GPS device at all times. Do you have one on you right now? You must have a global positioning device so I know where you are at all times. And you shall have, as a condition of bond, no contact with any witnesses in this case except through your attorney, Mr. Macon. And you can, of course, contact your own witnesses directly, but not witnesses who may be witnesses for the state. And we know that this lady was a witness for the state. Section 36.05 of the Texas Penal Code provides for felony punishment for any person who, with intent to influence a witness, offers, confers, or agrees to confer any benefit or of a witness or prospective witness in any official proceeding to testify falsely. Sir, it's clear, according to Horrid's testimony, that's what this is all about. And I'm going to ask the state of Texas to refer this also to consideration for a grand jury review. And the court finds that there is, based upon her testimony, that clearly meets those elements of that crime. The first condition of your bond is don't commit an offense. Any attempt to commit a crime or carrying out the commission of the elements of a crime constitute a violation of that bond. If this court discovers any further failings to follow bond conditions, then we'll bring you right back up here, and then it will your bond will geometrically increase, or it will be disallowed completely, and you'll have to be in custody until such time we have this trial. Are you setting this thing for trial?
Yes, it is on the trial list.
Let's get it done. And I don't want to hear anything about attempts to influence witnesses. Work through your attorney. He knows how to do things. That is all. Okay, I need Joseph.
Whenever y'all are done here. We need executive. As soon as they're done, he'll bring them out.
Which one? You got two cases here, Joseph
cases,
Benitez and Joseph. Oh, is that? Oh, I see. Mr. Gomez is also Mr. Benitez.
Motion to revoke probation. It's discussed. So.
Here's Brighton Scott's file, and I'll sign that when I get a motion to dismiss. Thank you.
We approached on this one day before yesterday, Your Honor. You just didn't have the report you needed.
Public safety report, and I have to have that by
That's
law now.
We covered.
When the court deals with any bond conditions.
I understand.
And I do have, I'm reviewing what purports to be a public safety report regarding Joseph Janelle Benitez Gomez, who is the defendant in these two cases. Correct. Cause numbers 25 CR 1813 and 22-40973. Charged with evading arrest or detention with a motor vehicle and fraudulent finance statement. Well, I guess false statements.
Yes, Your Honor.
Financial.
That's why he's on that's probation.
He's on deferred, right?
Correct, Your Honor.
A misdemeanor.
We had the probation officer here day before yesterday, and she covered the violations as well.
All these things I will.
Are you referring to me?
I thought it was for me, but I'm a few years.
Actually, both of them. No, I'm talking about this case. This case, and then
Is it,
now we've
Your
got
Honor?
I'm talking about the underlying indictment here on 40973, but he's been on probation for 5 years.
Yes, Your Honor. I mean, I was actually hired on just a short time ago.
Placed on probation on September 10th of 24, and it looks like April 26, 2025, he is alleged to have committed this new case of evading, which which would have occurred just
7 months into his probation, Judge.
come forward. You were Joseph Benitez? Okay, you were here with Mr. Paget, your attorney and the state's attorney. The court is reviewing the public safety report of the defendant, showing that he was placed on deferred or unadjudicated probation for the offense of fraudulent financial statement, a state jail felony for which he is on probation in this court and for which a motion to revoke probation has been filed as of December 15th of 2025. He also has a Class A misdemeanor resisting arrest or search conviction back in 2019. The motion to revoke probation in this new fraudulent finance case that he's on probation out of this court states the defendant committed the offense of evading arrest or detention on or about April 26, 2025, for which he is indicted for under 25 CR 1813, and that he failed to work faithfully at civil employment, provided a urine sample in October showing the presence of cocaine, admitted to the sheriff's office that he was using tetrahydrocannabinol or marijuana on or about June 3rd, 2025, failed to provide verification of performing community service hours, failed to abstain from the use of intoxicating substances, is in arrears on restitution of $5,906.48 from probation. How much? I guess this is the restitution that he was owed in the case he was placed on probation for in 2024.
That's correct.
Okay. How much has he paid in restitution?
$43.50.
And finally, failed to pay court assessed fees, is in arrears, and is failed to pay the minimal payments of $500 per month for restitution as directed. Okay. All of that being said, Mr. Patchen, on behalf of the defendant, what are you asking today?
We're asking for a reasonable bond, Your Honor. I will say this, he has stable roots in the community in Port Arthur, that is. At the time he was arrested, he did have a job. But where were you working at the time you were arrested?
Belmo.
Say it again.
Belmo.
Okay. What were you doing here? He's a scaffold builder is what he was doing, Your Honor. He's a scaffold builder. So he was having trouble getting a job. At the time he was arrested, he did have a job, in fact, and he still has a job if he gets out. The other thing I'll point out, Your Honor, is he wasn't aware that he had the warrant for the MTRP. He was arrested when he went to report. So he was not, I don't believe he's a flight risk. He knew there was a problem and he still reported. And he's been active in that. I think now if he's out, he does have a job and he can work. And I do not believe he's going to be a flight risk. He has roots in the community. So that's
Well, what
really
bothers me is, I know you're saying he's not a flight risk, but the grand jury has indicted him for evading arrest, fleeing. That's not good.
Okay. Yes, Your Honor, but I'm talking about a flight from the city, the state, or even the country.
May I
That's
ask
what
this?
referring to.
When can y'all be ready for a hearing on this motion to revoke probation? What's the earliest?
This case, the evading charge is indicted, and so
I'm talking about
it's
the motion to revoke probation on the state jail felony. When can we
Well,
get that?
my point is, Judge, we can be ready at any time because the case is indicted. Discovery is accessible for all parties.
Okay, when can
the other issue
defense
is,
be ready?
I'm not sure what he's going to plead true to and not. I mean,
I don't care. Yeah, we'll take it up at the time. He doesn't
well, I'm
have
not
to do it
sure we
now.
would need a hearing if he's going to agree to everything but the new violation. And I was hired in November. I received the
What do
discovery
you need?
in December.
How much time?
And I haven't even reviewed the discovery on because what happened was they dismissed it on a technicality and they refiled it. So I haven't even reviewed discovery with him. I haven't had an opportunity to even sit down and review discovery with him.
I'm
on the
sorry,
brief.
they dismissed what?
We
Re-indicted. the unauthorized use. of a
Okay,
motor
but the
vehicle.
motion though was filed December 15th. Right, and
Yes, sir.
this indictment occurs on December 3rd.
All we did was change the name of the officer that he evaded from, Your Honor.
Okay, that's what, first we're gonna do, we're gonna have a hearing on is this motion to revoke unadjudicated probation. He's been on probation for a while, and then this alleges not only the new offense as allegation number 1, but 8 other allegations of violations of probation. And that's what the court is concerned about in setting a bond, because we're talking about an allegation of evading arrest or detention with a motor vehicle. And he's already been convicted of resisting arrest or search earlier in 2019. Can you be ready in 4 weeks on a hearing, on a motion?
I don't know. What I would like to do is review the discovery on the new case, get an offer from the state. It may very well be we wouldn't need a hearing if my client was going to plead to both cases.
Why don't we review this in 4 weeks, one way or the
Yeah,
other?
I'm going to bust my rear end to get ready. I assure you
Yes,
that.
sir. And I'm concerned about this.
And I understand your concern.
Is the defendant a citizen of the United States? Are you a citizen of the United States,
So,
sir?
yes.
Okay, good.
One more safety concern to add for you, Judge. I want to read one line out of the reports.
Which report?
The reports on this evading detention.
Made by.
So the officers are responding to what is labeled as a disturbance, and it's of the nature of an aggravated assault with a deadly weapon. One of the witnesses said that this man pointed the gun at himself, his wife, and other subjects at that location. Say, the next time I see y'all are all dead. So any kind of a bond at this stage, the state would object to until the court has an opportunity to hear the motion.
Well, Mr. Patchett,
I have
is going to deny that at this time. And so I'm going to hold the motion in abeyance. There's some things that are very concerning for the court, and I would want this. Let's see if we can get this motion to revoke probation heard.
Yes, sir.
As soon as possible. We're going to set it for a review in 4 weeks.
And I'll do this. I'll get the discovery. I'll go out to the jail. I'll review that with him. I'll get an offer from the prosecutor,
sir.
and then
We'll set it.
I'll be
And
prepared.
if you're ready, fine. If you're not, you're going to have a.
Okay, I just want you to understand. I mean,
Yes, sir.
it's coming at me quick, and I haven't had it. So
Well, done. What I'm trying to do is freeze all of it right now. Let's freeze. And I know bond is important, but let's freeze until you get.
I'll do my.
You're informed comfortably.
Sure.
And
I'll be out to see.
this motion can be disposed.
Lori Gay Hinkle, 26W841130A and B. Your name?
Laura Gainville,
You smell of alcohol, I'm told, Ms. Hinkle. Are you
I
drunk?
was drinking last night.
Are you drunk?
No,
We're gonna give you a PBT, okay? My court officer is going to administer a PBT to you.
I
So,
was drinking till,
ma'am,
Go ahead and see the hallway.
we're gonna administer a PBT to you.
Go ahead and see the hallway.
And you'll go out and, so that goes to the prosecutor. That's the PBT. Lori Gay Hinkle, 26W841130A and B.
yes,
You're drunk.
no, sir. I was told.
You said no, sir. What's your name? Tell me your name.
My name's Laura Gainville.
You got a .166 on the PBT.
I was drinking till 4 o'clock in the morning. I didn't. No, that I couldn't believe that was.
You're still drunk.
No, it was,
Man, you've got a .166. Who drove here?
My friend.
Who's- Is this the guy here? Did he drive?
Sir Raymond, Sir Ronald Raymond Hamilton, the 11th president,
Slow down.
president
What?
of the United States.
Hang on a second. Who?
The 11th cousin to the United States president,
What's his name?
Sir Ronald Raymond Hamilton. The cousin to the president. Hamilton. Yeah.
The president of the United States?
Yes,
The president right now?
yes, sir.
He's shaking his head no. Why is he shaking his head no? If he's not the president, why?
No, he's not president, he's the 11th cousin.
11th cousin. He's shaking his head no. That he's not the 11th cousin. And honestly, I don't care if he's the brother of the president. It's not gonna help you, so I don't need to hear this. What I do want you to know, if you show up for court again drunk, we're gonna have a big problem. I'm gonna reschedule your case. Sir, you cannot let her drive. Do you understand?
Thank you, Judge.
Well, you know, you gotta,
Pledge allegiance.
I'm sorry,
Pledge allegiance.
pledge allegiance? Is that what you said?
Yes. I'm unjustified.
Just relax. Heather, give me another date, will you please? I should probably have you locked up until you go down. Give me another date.
We could do February 18th at 9:45.
Come on up here, sir. What is your name?
My name is Ron and
Did you drive her here?
yes, I did, in fact, mom alcohol when she got up.
Do you live with her?
Well, she stayed with me last night. She asked me 2 days ago if I'd come with her. So really happened. She left my house when she got.
Is she gonna have access to a motor vehicle?
No. Not have anything.
Do you own a motor vehicle, ma'am?
That's what
Does she?
a 2010 Ford Focus,
She owns it.
lightweight.
Well, hang on a second. You just told me she didn't have access. If she owns a motor vehicle, how does she not have access to the vehicle?
I'm a woman. Not just. I picked him last night.
Go down the hall, get your new date. It's going to be February 18th
February 18th.
at 9:45 in the morning.
You think 45 an hour, no alcohol.
Don't show up drunk.
Yes.
Don't show up after consuming alcohol.
Okay, sir.
We understand?
Okay.
Sir, I'm gonna let her go. I'm gonna trust you're not gonna give her those keys.
Thank you. I'm trying to get her into a treatment center for alcoholism.
All right, let's not have any further discussions here, okay?
Okay.
That's what I'm gonna do. Do not drive. Do you understand?
Yes,
Do not drive. You understand?
yes,
Sir.
Go down the hall. They'll give you a notice. Thank you. All right, let's call Moran here. People against Moran, Carrie Ruth Moran. File 16W810025.
Good afternoon, Ron. Good morning, Ron. Myself, for representing Ms. Moran.
Ms. Moran, your name?
Carrie
Ms.
Ruth Moran.
She's the one that has all the medical issues.
Yes, Your Honor, she's bedridden.
Go get the prosecutor.
Thank you, Ron.
How do you support, I'm sorry, go ahead. Where's McNamara at? Is he here?
Right here, Your Honor.
Oh, okay, I'm sorry. I'll be next. You'll be next. My apologies. I got just a lot going on here, all kinds of sobriety court sentencings today and
Understood.
good morning, Mr. Urick. How are you? Your appearance?
William Urick, on behalf of the good people of Woodhaven.
The good people of Woodhaven. I like that. Let me ask you a question. What did she allegedly steal?
I would have to refresh my.
Let me look. She did take $397 at a Myers. You ever been in trouble before, Ms. Moran?
No.
I don't want to get involved in this, but I'm not sure you don't want to just watch this one. She's got no money. She's got medical issues. The case is 9 years old. She hasn't been in trouble since. I try to not stick my nose in, but sometimes I can't help myself.
No, it is a very empathetic list of, I don't want to violate HIPAA, but she's had a lot of change.
I know. So you want to do that or you want me to take the plea?
If the court has no issue with the people moving for a non-proceed, we need to do something.
Go get a stip and fill it out to that effect and she'll wait here.
No objection.
Yeah, I'll wait right here. Ms. Moran, you don't want to
Yes.
you don't want to make me look bad, do you?
No.
I mean, I'm going to go out of my way here for you if you understood what I just did.
Yes.
Okay, but don't make me look bad. Okay? If you go out and do this again, they're going to have my picture in the front page of the local newspaper saying the judge is a bum. He let her go and I mean it.
I
Okay?
promised you. Yes.
All right, so let him write this up. I don't see any reason to pile on. I know you got several medical issues and I know that you're not wealthy at all, so let's let this go, but you gotta stay out of trouble, please, okay? They could have charged you, ma'am, with a 1 year misdemeanor here. You understand?
Yes.
So just bear with me. He's writing it up.
Want to recall the matter?
Nah, he'll write it up quick. I don't want to make you go back and forth here.
I'm sure all the clients ready to go. You're ready.
Well, I'm gonna take Mr. Nichols next, and then I'll go on to whatever you have. So if you got another one to attend to, Mr. Crawford, you can go work on that, and we'll go from there, okay? Just give me 1 second. Don't go anywhere, though. Mr. Urick's gonna write that up. All right, that's it. Come on up here. Thank you very much. You're moving to dismiss, right?
We are.
Case dismissed, ma'am. Good luck to you. I wish you well.
Thank you, Judge.
All right, now I wish you well with your health too, okay?
Your Honor,
Thank you.
Since got that's in the fraud.
Wait a minute. Slow down. I gotta slow down. I'll tell you what, I'll waive the fines on this.
Thank you, Your Honor.
I'm gonna waive the fines on this.
Thank you.
Fines and costs waived. Yeah, I know. Good luck to you, Miss Moran.
Thank
You're all
you,
set.
Judge.
Your business is over with us. Have a great day. Stay healthy,
You
please.
too.
Good luck. Thanks.
Thank you.
Kingsway Transportation, 25WA390224A and B. We show caused you. You forced us to show cause you. What's your name?
Charles Harvey.
Why haven't you paid these?
They're not my tickets, sir. I called and talked to the officer and someone else when they first issued the ticket. My company I lease out my trucks and trailers. And they issued a ticket to me, to Kingsway. Kingsway don't just own the trucks and trailers. They leased out. They're not up under my authority. People who drive the trucks and trailers run up under their authority. So I was telling them, I don't know why they issued it to me. It's supposed to be issued to whoever legally running the trucks out there. So,
You're the principal of Kingsway Transportation though, right?
yes, it's actually Kingsway Investment doing business as Kingsway Transportation. So that's probably why you got both names. But neither one of those companies has their authority. Neither one of my companies has authority to drive motor carrier on the road. They're leased to, at least my trucks and trailers out. And those guys have their own authority. They run. So I don't know why the officer put it to my, on the registrations, it has.
Well, you're the owner.
Right, of the I'm the owner of the vehicles.
Right, I know, but they wrote, these are attached to the owner. They could write them to the owner too. It's defective equipment and improper display of plate.
Motor carriers required to have a DOT MC number to run out on there, and anybody that runs up on a motor carrier, you have to do your own inspection. That whoever authority that is, they are responsible for everything, not the person who, you know.
You own the truck.
I just own the truck, but not the authority. It's like I'm a rider. It's like rider, you lease the trucks out to you, you go rent and ride the truck. I mean, that's just right.
Call in Mr. Urick, please. I'll get Mr. Urick. I got him.
Yes, Your Honor.
Can you come in here, please?
Of course, Your Honor.
Thank you. I'm gonna let you explain this to the prosecutor.
Okay. Yeah, but I mean, you know, semi trucks that runs on the road, you have to have a DOT or MC number to be out, to be legally on the road.
I get it, but you own the vehicles.
I own the vehicle, not the, but it's the authority, meaning that when you run up under the DOT or MC number, you're required by law to inspect your trucks, to make sure everything is legal and do everything legal on the road.
So am I if I'm a driver. Listen.
I'm not the driver.
Hang on. I know. Your name?
William Urick, I'm a city Wood.
I don't understand what he's trying to tell me here. We've show caused this company. These are Woodhaven tickets. He acknowledges that Kingsway Transportation, of which he's the principal, owns the vehicles. But he's saying they can't be held responsible, and I don't understand what he's telling me because, as you know, an owner could be cited for defective equipment or the driver or both. And he, as far as I'm concerned, is the owner, based on what I'm learning here. I mean, that's who they wrote him to, was Kingsway Transportation. So you can't just come in here 7 months later after the fact and tell me, Judge, I don't know these tickets. The second one's for improper display of plate, which are all functions of what the owner has to do. So I'm going to let you talk to him. If you have a different opinion or he convinces you, you can tell me.
Your Honor, we don't, both in the realm of civil infractions as well as misdemeanors. Corporate entities can be charged.
Right. I don't know why you're saying you can't be charged. You can go explain it to him for 5 minutes. If he doesn't buy it, you can go down the hall and post a bond and file a motion to set aside the judgment. You didn't show up. Your company didn't show up back on August the 5th. So you can't just come in here and say, no, this isn't my responsibility. You guys were supposed to be here. We sent you a notice. You should have been here. Go talk to him. And otherwise, you're going to have to post a bond and file a motion to set aside judgment. But
Thank you, Your Honor.
that's the best I'm going to tell you. Maui. Jerron Darrell Prince, 25B 726-159. I'm really concerned about this one.
Your Honor, Michael Crawford.
I don't know what I'm going to do with Mr. Prince. Your name? Counsel, I'm really troubled by this. He was in front of me on February the 16th. He pled guilty to a bond violation, a failure to violation of the bond.
January 16th, Your Honor.
No, I'm sorry, December 16th.
December, oh.
My apologies. So on December 10th, he was in front of me. I swore out a bond violation. He wasn't in front of me on the 10th. Forgive me. I swore out a bond violation. And it was for consuming alcohol. He came in front of me on the 16th. He pled guilty to the bond violation, and I told him to go test that day, and he did not test on that day. Why?
I didn't consume alcohol that day. It was marijuana.
I told you to go and test that day. Hang on. I told you to go and test that day, and you just blew off the order, and now I'm supposed to take you in this program?
Your Honor, that day we discussed that deal trying to go over there after court and it was closed. Then I went to work and I came back and like I stepped out of training. We discussed this and I showed you evidence and the Saturday.
What, who discussed this?
You and my probation officer at the time.
Wait a minute. Wait a minute. You haven't been in front of me since the 16th. I ordered you to go and test that day.
That was the day I showed you the pictures of the train. I've been going ever since.
So we had come back, Your Honor, on that bond violation. We had brought in the evidence we had about how we instructed him to get him back timely. By the training, we talked with the probation department. They also testified that they received notice from my client that there was an issue, and that's what stopped him from testing that same day. But as mentioned, Your Honor, he has been testing ever since, and he hasn't had any problem. We did discuss this with the court. We thought we were beyond that here today.
I didn't even. Have you been representing throughout?
Once we began discussing, I remember I had represented him a couple times prior, and I do remember that particular hearing where we went over this.
Is that like in early January?
No, I think it was more like December, when in December. Yes. Yep.
I don't know what happened on this. I'm gonna have to check into this.
Sure, Your Honor.
I sure didn't make very good notes. John Cole,
Oh,
let me double check something here.
Your Honor, when he appeared that day on that bond violation, he had emails with him that he communicated with probation, explained what was.
Tell Beth I need her on this one.
Might have looked at it.
Why don't you have a seat 1 second right behind you there? Tell Beth I'm gonna need her on that, please. So I don't know what happened on this, but it looks like another show cause was issued. So he was in front of me on a bond violation, was sworn out by Ms. Tassino on the 10th. And it looks like it was for being positive for THC, not alcohol. And then I found him guilty of a violation of bond on December 16th. And I ordered him to test that day. And then I'm told that we had a hearing by Mr. Crawford, I think, where the gentleman was stopped because of the trains. He took pictures. But then on the 22nd, she swore out a new violation saying he didn't appear for testing as ordered on December 16th. And I was going to hold a hearing on January 7th, which was the same day as the sentencing. We came here on the 7th, and I don't know if I ever held a hearing or not, but I was concerned because I didn't even know this gentleman. I thought this was Judge Hessen's case. He's got a 461 on the breathalyzer, so for the blood draw. So I want to know what kind of notes you can decipher there.
Yes, Your Honor. So in Emily's file,
You are correct as far as the flow. He was violated for being positive THC during bond. You ordered him to go for that testing on the 16th. He did not go. At the last hearing on January 7th, we were prepared to sentence him into sobriety court that day, but Emily had put Judge Hessen's name on the screening report. You thought that it was Judge Hessen's based on that information. Because he had been on bond for such a short time and under bond violation, then you scheduled sentencing to today.
So I don't need to address,
I don't believe there was a finding on the 7th because you felt that the case was Judge Hessen's. So I don't believe you held the bond violation hearing or sentencing.
does that strike a bell?
There wasn't a sentencing, but we had the fullest discussion we could. It was essentially the hearing, if we informally call it that. Everybody testified. He testified as to what happened. You thoroughly wondered. I asked him some questions and
And then I said I was not going to proceed with the bond violation.
yeah, I think because of the Hessen.
Are you prepared to do this? Do you know that this is like top 2 highest breathalyzer or blood draws I've had in my 32 years as 31st, that's my 32nd year as a judge, and 42 years as a lawyer? You're lucky you're not in a casket somewhere. So I hope you're scared to death. If you're not going to make it. You had a 4.61.
Can I say something, Your Honor?
I'd love to hear it.
Your Honor, I've been sober since November 7th, willingly, and I came in myself to turn myself in because of the warrants. And since I've been on probation, I've been going to my AAs, testing and everything. And I want to say, due to the probation, it pushed me on the way to be sober. And I appreciate everything this courthouse has done to help me do that.
You had young daughters in the car.
Yes. Yes. And I'm ashamed of that.
You drove like a maniac.
Doing the speed limit, but I was.
The point is that you drove off the road on Allen and crashed into a ditch. The officer observed tire marks north of the vehicle's location stretching back 100 to 150 feet in the snow. They indicated that the vehicle was traveling southbound on Allen, drove off the road to the right south, he says, of Hidden Oaks. The vehicle continued traveling southbound through the ditch, came up onto the north side of the embankment, struck a manhole cover, and then came to a final rest in the location where it was found. So, I mean, this was like, really, you are so fortunate that you didn't die or any of your kids. And this scares the devil out of me. If it doesn't scare you, they should have charged you with OWI 3. You got 2 prior convictions. You got one in 2011 and one in 2022. I don't know who dropped the ball on this one. Maybe they made up their mind. I don't know. But at any rate, he pled guilty to operating under the influence occupant less than 16, which is a 1 year, which I'm fine with. But wow. And I'm going to take you at your word. I see the pictures in here. Your lawyer's a good lawyer. He wouldn't lie to me. But man, I'm worried about this one. I don't know why they didn't charge that. Boy, somebody did drop the ball because they went state. All right, counsel, what would you like to say?
My client already kind of spoke to this a bit. I mean, he feels terrible and ashamed about this. You know, he needs help. He hasn't had control for he's probably able to say he's starting to get his arms around it a little bit, and he's looking forward to being in the program to continue to stay on the right track. He understands he has responsibilities, children. He's got what's left of his life left, so he wants things to be better. He genuinely does, and And I think anybody who would talk with him would realize that. So he feels terrible about things so far, but he's going to improve. He realizes he needs to change his life. He understands and jeopardize his life at that time and his health moving forward. This level of drinking.
Anything?
Attorney.
I can't not send you to jail today. There's no way I can do it in this case. It's a third offense. You had 6 times the legal limit. You had kids in the car. You drove like a maniac. And I get the fact you just did it because you were intoxicated, not because you were having a joyride. 2 years probation. Listen, there's nothing I can do on this one. There's nothing I can do. I'm not giving him a long time. I'm going to give him credit for what he's done. 2 years probation. You cannot leave the state without the consent of the court or violate the law. If you change your address, your place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no marijuana, no illegal drugs. You're not going to any place that sells or dispenses alcohol as its primary source of business, like a bar. You're not going to a party where there's alcohol or drugs. Submit to chemical testing PBTs and ETGs on demand at probation. You're to submit to chemical testing PBTs and ETGs on demand at probation. Complete an additional 90 days on the SoberLink device. Attend 12-step meetings 3 times a week and provide written proof. Obtain an AA/NA sponsor. Attend all substance abuse treatment in a facility approved by probation. Attend the Victims Impact Panel. Attend and complete the ARM program. Report to sobriety court status reviews with me every 2 weeks, and obtain and maintain employment with proof provided to probation. So those are so far the terms and conditions here. Also, he has 1 day credit coming. Just give me 1 second, counsel, okay? I'm in order that you pay fines in the amount of $200, costs in the amount of $250, $75 victims' rights fee, $50 justice assessment, 5 1/4, screening fee 60 for 585. Probation fees are $480, bringing your total to $1,065. You have $360 in sobriety court fees, bringing your total to $1,425. I'm going to go with attorney fees. I'll still only go 40. That's $1,465. Court work program fees, $175. That brings your total to $1,565, $1,640. I'm going to order 20 days.
But she does also have a $45 suspension fee, just to let you know on that.
Okay, so you'll have to pay that too. 20 days jail credit, 1 served 19. I'm going to have you serve 9 days jail forthwith, 5 days on the court work program, and 5 days of community service. I'll let you do that community service. I'm going to give you all the way to June the 15th to complete your community service. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer if you cannot afford one. If you violate, you could get 1 year. This pains me to do it when I see somebody doing well in bond phase, but I just cannot, under these circumstances, justify not sending you to jail today. Can he pay? He has a bond of $200. How much more can he pay today?
Your Honor, my client was prepared to pay $100 today.
So is the bond in his name? It is, so he's going to pay $300 today. And then how much can he afford to pay weekly? Well, let's start.
Your Honor, presuming he has a job and he gets out of jail, you propose to pay $300 a month. I really can't promise that until he gets out.
Okay, let me check something here. Pay $300 today.
You want a client to pay?
He has a bond.
Oh, okay.
$300 today, 300 per month. I'll start that beginning March. The 25th. Okay? And if at any time you need more time, you tell the court and I'll be glad to give you an extension. You know, if you weren't coming up here to meet the probation, you could tell me and you could call and I'd go on Zoom with you and we'd go from there. I do wish you well, sir. Good luck to you. Thank you.
And Judge, I'm gonna take his soberly deactivated for the jail.
Yes.
Oh my God, I was typing. Hi, everybody. That's the end of the show. I don't know if you noticed. I definitely noticed because, you know, I heard the music and stuff. That guy went to jail for 9 days. Yeah. And then, you know, he has some court work details stuff to do. And after that court work details stuff, he has to stay on the straight and narrow, or he goes to jail for a year. But that's not near as bad as the other guy before him who got stuck in jail with his fines raised to $60,000. I was definitely paying attention during that one too. His fines were raised to $60,000 and he had to get an ankle monitor. I definitely know what's going on. And the lady at the very beginning, she's training her children to be thieves, and it's nasty stuff. Ladies and gentlemen, that's just a taste of the kind of stuff you get every night of the week here at the Court Gallery. Come on by and see us. We'll be here again tomorrow. Same Wolf time, same Wolf channel. It's 8 p.m. Central Time, 9 p.m. Eastern, in case you're wondering. It's been a pleasure serving you this evening. Thank you very much, everybody, for hanging out. What's going on in chat here? All you people are crazy and you're wonderful. I appreciate all of you, everybody. Have I forgotten to mention anything? Because I'm a horrible host and I get way too scatterbrained while I'm doing these things. Did I forget to mention anything? I don't think I did. I think I got it all. Ha! Interesting. Well, don't forget, ladies and gentlemen, I am your humble lone wolf Usul. I'm your curator for these here videos, and I'm your humble host here at the Court Gallery. And I support the message to teach your children well. And let your little chihuahuas hang out on the couch together because they love it so much. It's your buddy. I'll see you guys in a bit. I'm your lone wolf Usul, and I am out. Weekend is firing up to be quite a show. Might even be kind of a long one. So don't forget about the weekend show. Every Saturday, brunch, noon Eastern, 11 a.m. Central. Come on by. Every so often, I like to remind you guys why we do this in the end. So, keeping that in mind, Bueller, Bueller, Bueller. Teach your children well.